Dear learners, welcome you again in this Swayam MOOC course on Environmental Politics, Theories, Concepts and Debates, Week 8, Lecture 3 on Judicial Intervention and Environmental Justice, in which we will be discussing the different judgments made by the Honorable Supreme Court and High Court. Along with that, we will be discussing the public interest litigations and its impact on environmental policies. Along with that, we will be discussing the judicial activism and its role in enforcing the environmental laws. So let's begin, learners. So here we can see that Indian courts have played a transformative role in environmental protection through the judicial activism. And here, by interpreting the Article 21, that is to right to life, the Supreme Court expanded it to include the right to a clean and healthy environment, which we have discussed in the previous lecture. In this regard, the landmark judgments introduced key principles, for example, like absolute liability, that is about the strict accountability for hazardous industries. Then the polluter pays, it means the compensation for environmental damage, those who will do this. And then after the precautionary principle, that is about the preventive action against the ecological harm. So here the courts have also ensured a strict enforcement of environmental laws through the public interest litigations, that is in form of PILs. And this proactive approach has strengthened environmental governance in India. So here we can see that these judgments have set global benchmarks in environmental jurisprudence and continue to shape India's sustainable development policies. So these judgments have established key principles like sustainable development, polluter pays, and absolute liability, along with the precautionary principle. So now here we will be coming up the some of the important judgments in the different cases made by the Supreme Court or the High Court. So here we can see that in the Olgam Gate gas leaked from Shriram Food and Fertilizers, which was in Delhi, harming people and the environment, occurred just 2 years after the Bhopal gas tragedy, which raised the urgent concerns about the industrial safety. And here, legal issues whether the industries using the hazardous substances should face strict liability or a higher standard of accountability. So, in this regard, the landmark judgment in which the Supreme Court rejected the British Reliance versus Fletcher strict liability rule as inadequate and introduced the absolute liability doctrine, making hazardous industries 100% liable for damages regardless of precautions taken by. And here, the key principles established no exceptions allowed, unlike strict liability, which permits some defenses. And here, polluter must compensate fully, so victims entitled to complete redressal. And here, industries must ensure safety measures mandated stricter regulations for the hazardous activities. And here we can see that it pioneered environmental jurisprudence in India, led to the Public Liability Insurance Act of 1981, and that is about the compulsory insurance for hazardous industries, and strengthened judicial activism in protecting citizens' right to a healthy environment, which we have discussed that it was incorporated in the right to life, that was in Article 21. And here this case remains a cornerstone of environmental law, ensuring corporate accountability and victim justice in industrial disasters. Along with that, strict liability versus absolute liability. So here, strict liability, that is specifically, as I just mentioned, Reliance versus Felcher, which holds industries liable for harm which are caused by the hazardous activities, but also allows exceptions, like some of the exceptions like the act of God, plaintiff's fault, etc. And on the other hand, the absolute liability, which is basically in the context of MC Mehta case, which we will mention, imposes no exceptions. Here, industries are fully liable for the damages from dangerous operations, ensuring stronger victim protection and corporate accountability in environmental disasters. Then, after the compensation for victims, so here the absolute liability doctrine ensures victims of industrial disasters will receive full compensation without proving negligence. And here, courts mandate polluters to cover medical cost, rehabilitation, and damages, prioritizing victim welfare over the corporate interest. So here, this principle established in MC Mehta versus Union of India case strengthens environmental justice and holds industries accountable for harm caused by the hazardous activities. And then after, we can see that it pioneered environmental jurisprudence in India and led to the Public Liability Insurance Act of 1991, which was based on compulsory insurance for hazardous industries, and also strengthened judicial activism in protecting right to a healthy environment. Now, here we can see that the MC Mehta versus Union of India case 1997, which was basically as the Taj Mahal case. And here, this landmark environmental case addressed the yellowing of the Taj Mahal, which was caused by the air pollution from nearby industries, particularly the Mathura oil refinery. And in this case, the Supreme Court recognized the threat to this UNESCO World Heritage Site. So, ordered relocation of polluting industries, that was from the Taj trapezoum zone, then after the conversion to cleaner fuels, that is shifting to the CNGs, then after the strict emission controls, especially for the industrial refineries with a special reference to Mathura refinery, and environmental protection measures, which may include tree plantations. So here the judgment established the precautionary principle in Indian environmental law, emphasizing preventive action over the damage control. Along with that, it set a global precedent for protecting cultural heritage from the industrial pollution, balancing economic development with ecological conservation. And here it also established a Taj Protection Fund for the conservation efforts. So, this impact was seen by reduced sulfur dioxide and particulate matter emissions around the Taj Mahal, and set a precedent for protecting heritage sites from pollution. Now here we will be coming up to the next case, that is about twin MC Mehta versus the Union of India, that was of 2001, and it is basically based on Delhi vehicular pollution case. So here this landmark case addressed Delhi's hazardous air pollution, primarily which are caused by the vehicular emissions, and in this regard the Supreme Court ordered about the compulsory CNG conversion for all public transportation. And in this regard, we can see 8,000 plus buses and 55,000 autos switched to cleaner fuel, that is in form of CNG, using CNG. Then we can see that ban was imposed on 15 plus year old commercial vehicles, that is just to phase out 40,000 polluting vehicles, and along with strengthening emission norms for the new vehicles. So in regard, we can see, for example, Delhi's PM10 levels dropped by 40% within 5 years post implementation of it. And here the judgment also recognized clean air as fundamental right under the Article 21, and inspired nationwide anti-pollution measures like the National Clean Air Program of 2019. Now we will be coming up to the next one, that is about the Vellore Citizens Welfare Forum versus the Union of India case, that is of 1996. And here it's a landmark judgment by the Supreme Court of India concerning environmental protection. And here the case involved pollution caused by the tanneries in Tamil Nadu, which discharged untreated effluents into the agricultural lands and water bodies. So, in this regard, the court upheld the precautionary principle and polluter pays principle as a part of Indian environmental law. Along with that, reinforcing that industries must operate sustainably. And here, the court directed the closure of non compliant tanneries and ordered compensation for affected residents. So, here, this judgment emphasized the importance of like balancing environmental protection with the industrial and economic growth and development, and also marked a significant shift toward stricter environmental governance in India. Then after we can see the TN Godavaran Triplet versus the Union of India case 1996. And here we can see it was again a landmark case where the Supreme Court expanded the definition of forests under the Forest Conservation Act of 1980, which we have discussed in the previous lecture. And here it is to include all lands recorded as forest regardless of its ownership. Along with that, we can see that it imposed a nationwide ban on deforestation without the government approval, and also introduced continuous judicial monitoring of the forest conservation efforts. So here we can see that this case transformed environmental governance through active judicial intervention and strict forest protection measures in the context of Forest Conservation Act 1980. Now here we will be coming to the Indian Council for Enviro Legal Action versus the Union of India 1996 case, that is as Vichiri Village case. And here we can see that is this case which dealt with severe chemical pollution by the industries in Rajasthan. And here the Supreme Court held polluters absolutely liable for environmental damage and enforce the polluter pays principle here. And in this regard, it ordered the responsible companies to pay for remediation of the contaminated soil and water. And here we can see that this case reinforced corporate environmental accountability and also marked a milestone in Indian environmental jurisprudence. And here we can see that how this order strengthened the hazardous waste management laws, which later on led to the making of hazardous waste rules in 2008. Now we will be coming to the most important movement, a kind of public movement, that is as Narmada Bachao Andolan. And here this movement also filed a case against the Sardar Sarovar Dam project in the, and here this case was between the Narmada Bachao Andolan versus Union of India, that is in the year 2000. And here we can see that it concerned the Sardar Sarovar Dam's environmental and it's on it's on human impact. And here the Supreme Court allowed the dam's construction, citing national development, but also stressed on compliance with the environmental safeguards and proper rehabilitation of the displaced people of that region. And here the court held that sustainable development includes the balancing between the environmental protection and economic growth and development. Though it was controversial, the judgment affirmed the government's authority to undertake large infrastructure projects under the judicial supervision. Now here we have come up to the second section of today's lecture, that is the PILs, that is in form of public interest litigations, and what are their impact on environmental policies. So here we can see that the public interest litigations have basically emerged as a transformative force in shaping India's environmental policies and jurisprudence. And here, these are the legal instruments which basically enable by the liberal interpretation of locus standi, which have allowed citizens and organizations to to approach codes for the environmental protection. And ultimately it led to the different landmark judgments, as now just I have mentioned, that have redefined India's ecological governance framework. So here the pioneering cases filed by the environmental activist MC Mehta in the 1980s and 90s decade, which set the foundation of it. So before moving forward, quickly we will see the brief introduction of MC Mehta. So here Mr. MC Mehta is a renowned Indian environmental lawyer and public interest litigator, and he has filed numerous landmark cases before the Supreme Court, leading to critical judgments on pollution control, environmental protection, and sustainable development, which we have just mentioned just now in the context of different cases. And here his efforts earned him global recognition, including the Goldman Environmental Prize and also the reputed Padma Shri Award. So here we can see that the impact of public interest litigation extends beyond courtroom victories to substantial policy reforms and institutional changes. And here these PILs have also democratized environmental protection by enabling public participation in governance, as we have also seen in the context of Delhi vehicular pollution case, which transformed the urban air quality management. And here the judiciary, continuing the mandamus approach in many public interest litigations, that is just to ensure a kind of ongoing supervision of implementation, though this has also raised questions about judicial overreach into the executive domains. And here the establishment of specialized bodies like the NGT, that is in form of National Green Tribunal, which we have discussed in the previous lecture, can be traced to the judicial activism demonstrated through PILs, created a dedicated forum for environmental dispute settlement and resolution. Along with it has also incorporated the international principles like polluter pays, precautionary approach, and sustainable development. So now here we can see that some of the major challenges are also there, which persist in form of like delayed implementation, which is very common in India, especially uneven enforcement across states. In some of the states it is like enforced in a more like transparent way, in a more like what is there in the policy, and in some of the states we can see that still it is in process of implementation, and sometimes protract litigation that basically dilutes the urgency, the importance of environmental concerns. But even though we can see that despite these challenges, PILs, that is public interest litigation, remains an indispensable tool for the environmental justice in India. It means how they are actively like playing their role in establishing environmental justice in India. And here we can see that they have successfully expanded the constitutional interpretation of Article 21 in the right to life, which is expanded to the right to live in a healthy environment. And along with that, it also encompasses the right to a healthy environment, just now I have mentioned, compelled the industries to internalize environmental cost and kept the government agencies accountable for that. In this context, the recent PIS addressing the climate change issues, which indicates the evolving nature of environmental jurisprudence, that is just to tackle these contemporary environmental challenges. And here, the PIL's mechanism has essentially created a kind of parallel system of environmental governance. This basically the courts actively participate in policy formulation, along with that monitoring, complementing, and sometimes compensating for legislative and executive actions. As we can see in India, which balances economic development with the ecological sustainability, environmental protection, and here PILs will likely continue to play a very significant role in shaping this trajectory. So here, serving as both a watchdog and a catalyst for progressive environmental policies while adapting to new ecological challenges and governance paradigms. Now we have come up to the last section of it, that is that what is the role of judicial activism in in the enforcement of environmental laws. So here we can see that judicial activism has played a very important role in strengthening environmental governance in India. And here we can see like judiciary often stepping into just to fill the legislative and executive gaps, especially in the context of the implementation of environmental laws through their innovative interpretation of constitutional provisions in the changed time and space. That is just to incorporate the need of environmental issues. And here, by adopting an expansive reading of Article 21, that is basically about the right to life, and here courts have recognized that clean and healthy environment is basically embedded in this right to life, and it is an fundamental to human dignity and survival too. And here we can see that this proactive judicial approach, that is in form of judicial activism, has ultimately led to the development of critical environmental jurisprudence, which we have just mentioned in the previous slides, that is about including the principles, important international principles like absolute liability, polluter pays, and sustainable development, which have been like instrumental in holding the industries and governmental agencies accountable for it. Now, here we can see some of the important landmark cases in this regard. So here we can see that one of the important and popular environmental activist, that is Mr. MC Mehta versus Union of India, that is especially in the context of Taj trapezoum case that was in Agra. Then after the Vellore Citizens Welfare Forum versus the Union of India exemplify how judicial interventions have compelled, pressurized the industries to adopt cleaner technologies and also pay for the ecological damage that they have done in their process of industrial and economic development. Along with that, we can see that judicial activism has been very crucial in enforcing the compliance with the existing laws, especially the government agencies, those who have failed to act according to these norms and laws. And here the Supreme Court and high courts have frequently used continuing mandamus orders requiring regular progress reports on pollution control measures, forest conservation, and urban air quality management. And here, for instance, in the Delhi vehicular pollution case, the judiciary mandated the transition to CNG fuels and imposed restrictions on the polluting vehicles, directly influencing the national air quality policies. Similarly, the Govardhan case led to the stricter enforcement of the Forest Conservation Act by bringing all forested land under the legal protection regardless of its ownership. It means that whether it was under the entitlement of private people, but even though these lands, forested lands, will come under the legal supervision and monitoring. However, judicial activism in environmental matters has also faced criticism for overstepping into the policy making, a kind of interference in the works or functions of the executive, with some arguing that courts lack the kind of technical expertise to dictate environmental governance. But despite these concerns, the judiciary intervention have been vital in safeguarding ecological balance and upholding public trust doctrine, ensuring that natural resources are preserved for future generation. And it can only be possible when the governments will shift their policy to sustainable development. Now here we can see the creation of specialized institutions too, that is in form of NGT that we have discussed in the previous lecture, that is National Green Tribunal, which further underscores the judiciary roles in institutionalizing environmental justice. And here we can see that judicial activism will remain essential in addressing the emerging challenges like climate change, litigation, and corporate accountability in this regard. And here, reinforcing India's commitment to sustainable development while maintaining checks and balances in environmental governance. So these are the activity questions. These are the references which you all learners may use as further reading. Thank you.